Good evening po sa lahat. Let us now answer the question, can Congress revoke or modify decisions of the Supreme Court? My answer to this is yes. How does Congress do this? It may do this by, number one, enacting a new law that repeals the old law from which the Supreme Court decision was based, or number two, amending the old law, thereby attaining an interpretation that will negate the decision of the Supreme Court on the matter. Of course, Supreme Court decisions which have been promulgated prior to the enactment of the new or amendatory law will remain in full force and effect. They will not be revoked or modified. But any subsequent controversy dealing with the same facts will now have to be decided by the Supreme Court in accordance with the new or amendatory law. This is so because the function of the Supreme Court is only to render an interpretation that will give effect to the current legislative intent as reflected in the new or amendatory law. Otherwise stated, the Supreme Court cannot give an interpretation contrary to the new or amendatory law. For example, Article 36 of the Family Code allows the nullity of a marriage on the ground of psychological incapacity. Let us suppose Maria filed a petition in court to have her marriage with Pedro declared null and void due to the latter's psychological incapacity. Pedro contested the petition, but the court rendered a decision in Maria's favor. On appeal, the Supreme Court affirmed the decision of the lower court. Later, Congress passes a law repealing Article 36 of the Family Code. This means that psychological incapacity is no longer a ground for nullifying a marriage. Now, it is in this manner that Congress revokes a Supreme Court decision by making it no longer applicable to subsequent controversies dealing with the same facts. But is there an instance where Congress can actually change or modify an existing Supreme Court decision? The answer is yes, and my basis is Article 22 of the Revised Penal Code, which states that penal laws shall have retroactive effect insofar as they favor the person who is not a habitual criminal. Now, when the law subsequently enacted by Congress is favorable to a convict whose punishment has been affirmed with finality by the Supreme Court, such punishment will have to be changed or modified. For example, Congress before passed a law, Republic Act 7659, imposing the death penalty for certain heinous crimes. Let us say X was convicted of a heinous crime like murder by the RTC and was meted the death penalty. On appeal, the Supreme Court affirmed X's conviction. Subsequently, Congress passed Republic Act 9346 prohibiting the imposition of the death penalty. Now, since Republic Act 9346 is favorable to the convict, X in this example, the said law will be given retroactive application such that instead of the death penalty, X's punishment will have to be changed or reduced to reclusion perpetua. So yan lang po. Good evening and salamat sa lahat.